Good evening, ladies and gentlemen, honored guests. My name is Lawrence Smith. I am a member of the Dole Institute Student Advisory Board. I would like to welcome you to tonight's events. On behalf of the Dole Institute, I have 3 requests. One is to please turn your cell phones off. We will have a question and answer session immediately after the program. If you have a question, please raise your hand and one of our staffers will bring the microphone to you. Finally, do ask a single question. Our director does not tolerate filibustering during questions. It is my honor to introduce the Associate Director of the Dole Institute of Politics, Barbara Ballard.
Thank you, Lawrence. We appreciate our Student Advisory Board here very much. This is our Constitution Day program, and I'll say good evening, and it is a pleasure to have you here. And I thank you for anyone who's interested in what's going on with the Federal Health Care Act and the law. You will find out a lot about it. Last year, for many of you who remember, our program for Constitution Day was Snyder versus Phelps. And people thought perhaps we were going to cover more about what Phelps and Snyder was all about. We didn't. We covered the Constitution in terms of the First Amendment. And that's what we're going to do tonight as well. But before, if you'll look in your program and open it, please, we'll turn to the section that talks about United States Constitution. One of the things that the Constitution Committee has asked us to do is open the Constitution programs with the preamble. And for those of you who have been to our program, and by the way, this is our 6th Constitution Day program, you'll know that we do the Constitution. So some people have bells, and they're going to ring them. They're not very loud, so they're not terribly obnoxious. Okay, but at this point, we will start, and I will start it. And if you're in your program, if you will please join us. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings and liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Thank you very much. The only brief announcement I will make is please look on the back of your program for our upcoming programs, and we hope that you will attend those, and especially our study groups on Tuesday and Wednesday from 4 to 5:30. The federal health care law, is it constitutional? The Federal Patient Protection and Affordable Care Act includes a requirement that all persons have health insurance coverage starting in 2014. Those who do not will have to pay a penalty to the federal government. Some have argued that this requirement is unprecedented and exceeds the powers of Congress, a position one federal court of appeals recently adopted. Others respond that the requirement is essential to make the system work and that it is within the power of Congress to regulate matters affecting interstate commerce, a position that another federal court of appeals recently adopted. Ultimately, this issue will have to be resolved by the United States Supreme Court. With both sides wanting the court to review the health care law, it seems inevitable that the court will grant review soon and schedule argument in the spring, with a decision likely before the end of June 2012. At this time, I would like to introduce our panelists and our moderator. We are very pleased to have with us this evening Gregory Katsas. He is a litigation partner in the Washington office of Jones Day between 2001 and 2009. Mr. Katsas served in many senior positions in the United States Department of Justice, including Assistant Attorney General for the Civil Division and Acting Associate Attorney General. During that time, Mr. Katsas argued or supervised most of the leading civil appeals brought by or against the federal government. He has argued almost 50 appeals, including cases in every federal appellate court and the U.S. Supreme Court. His cases have included such topics as the detention of enemy combatants at Guantanamo, partial birth abortion, national security letters, physician-assisted suicide, and the constitutionality of the Pledge of Allegiance. In 2009, Attorney General Michael Mukasey awarded Mr. Katsas the Edwin Randolph Award for Outstanding Service, the highest award bestowed by the Department of Justice. Mr. Katsas is currently involved in leading one of the constitutional challenges against the recent health care legislation. Mr. Katsas is a graduate of Princeton University and Harvard Law School, where he served as executive editor of the Harvard Law Review. After graduating from law school, he served as a law clerk to Judge Edward Becker of the U.S. Court of Appeals for the Third Circuit and to Justice Clarence Thomas of the Supreme Court of the United States. Catherine Stetson. She's a partner in the Washington office of Hogan and I think it's Lovells. Kate Stetson is the director of our Appellate Practice Group, which in 2010 and 2011 secured a coveted spot on the National Law Journal's annual Appellate Hot List. She has been recognized by the American Law magazine as one of the top 45 women under 45 among AmLaw 200 firms, and also by the National Law Journal in 2009 and Washington Magazine in 2006 as one of Washington's top 40 lawyers under 40. Kate has argued in the U.S. Supreme Court, in most of the federal courts of appeals, and in multiple state appellate courts. She has filed dozens of petitions and merits stage briefs in the U.S. Supreme Court and has briefed hundreds of matters on appeal. Before joining the law practice, Kate served as a judicial clerk to the Honorable Stanley S. Harris of the United States District Court for the District of Columbia and the Honorable David S. Tattle of the U.S. Court of Appeals on the D.C. Circuit. Ms. Stetson is a graduate of Duke University, where she was cum laude, and she earned her J.D., Order of the Cough, at the University of Virginia School of Law. Our moderator this evening, and also the person when we're planning our program we go to and ask for his assistance, will be Steve McAllister. Steve McAllister is a native Kansan who grew up in Lucas, Kansas. For those of you who've never been to Lucas, Kansas, you know about Lucas, Kansas. If you haven't been there, you need to go find out about Lucas, Kansas. He graduated from the University of Kansas in 1985 and from the University of Kansas School of Law in '88. Following his graduation from law school, Steve clerked for Judge Posner of the United States Court of Appeals for the Seventh Circuit in Chicago, and then for Justice Byron White and Clarence Thomas of the Supreme Court of the United States. In 1993, Steve returned to University of Kansas School of Law as a visiting professor of law. He served as dean of the KU Law School from 2000 until 2005, and he won the W.T. Kemp Award for Excellence in Teaching in 1999. As a scholar, he has written on a variety of constitutional topics. He served as the first state solicitor of Kansas, assisting the Kansas Attorney General's office in state cases raising important constitutional issues. The panelists will debate and discuss the question whether the health care mandate is constitutional. And it is my pleasure to turn it over to Steve McAllister, and would you please give our guest a warm welcome.
Thank you, Barbara. I think the plan for the program is to allow each of our guests to make some opening remarks, present their side, if you will, of this issue. Then I have some questions for them, and then we will turn to your questions. So be thinking of things as you listen. We didn't actually talk about who was going to go first. I don't know if you had agreed upon that.
I'm the challenger.
The challenger shall go first. So Greg will make the first remarks, and then Kate.
Thank you, Steve. Thanks for having me. It's a pleasure to be here and a great pleasure to share the stage with my friend and former co-clerk, Steve McAllister. So the main constitutional question focuses on the individual mandate, the requirement that every American beginning in 2014 buy a package of health insurance benefits specified by the government. That really tees up the broader question, which is whether the government has authority under the Commerce Clause of the Constitution to force American citizens to buy goods or services that they don't want. The relevant text in the Constitution provides that Congress has authority to regulate commerce among the several states, or interstate commerce for short. What does it mean to regulate interstate commerce? It pretty clearly means one of two things. First of all, Congress can prohibit interstate commerce that it doesn't want. So it can, for instance, prohibit trafficking in marijuana or illegal drugs. That's a standard Commerce Clause authority. The other major thing Congress can do is it can specify the terms of lawful commerce. It can say, to pick an example from the New Deal, that if you're an employer hiring people, you must pay them a minimum hourly wage and you can't make them work more than a maximum number of hours per week. Or to pick an example from the civil rights cases in the 60s, if you're operating in commerce a public accommodation like a hotel or a restaurant, you have to take all comers regardless of race or sex or criteria like that. Those are the core Commerce Clause authorities sanctioned by history and that seem to count as regulating commerce. What doesn't seem to fall into the rubric of regulating commerce is forcing people into commerce so that the government can regulate them. People who are not engaged in selling health insurance, people who don't want to purchase health insurance, people who are sitting at home in their living room, complete strangers to the market for health insurance, and the government, for its purposes, is saying, we want you to engage in commerce, to be in this market so that you can be part of our regulatory system. That does not, in an ordinary understanding of the word, seem to be regulating commerce. What I just said is also sanctioned by history. Congress literally has never before tried to use the Commerce Clause power to force people to buy goods and services. Think of what an obvious and attractive power that would be if it existed. In the framing era, one of the major problems that the framers confronted was how to build up a system of national industry. Well, what better way to build up the industry of the new nation than to simply force people to buy American goods and services? And yet Alexander Hamilton, the great nationalist that he was, in his report on manufacturers, lists a whole series of measures that he thinks Congress can and should do to build up the national economy. It never even occurred to him that forcing people to buy goods and services should be on that list. Fast forward to the New Deal era with the most aggressive assertions of regulatory authority by the New Deal Congress and by President Roosevelt. They wanted all sorts of price supports to take the country out of the Depression. Well, what better way to have price supports and stimulate the economy and get things moving again than to sort of mandate that people buy things? Never even occurred to them, not even the New Deal Congress, not even FDR. Congress has never before tried to do that, and that has legal significance because the Supreme Court has said that if there is a power that has sort of been lurking unexercised for some 230 years, even though one might think it is attractive and tempting for Congress, if it has never dawned on anyone to assert that power until today, that's a pretty good indication that the power doesn't exist. So we think we have text and history cutting in our favor. Let me talk for a second now about precedent. I know there are many non-lawyers in the audience. Bear with me. I'm just going to talk about one case. That's the case of Wickard against Filburn, which is the height of the New Deal court. Roscoe Filburn is a farmer who sought to do nothing more than grow some extra wheat to feed his own family. Unfortunately for Mr. Filburn, he was subject to a New Deal era prohibition on growing more than a fixed amount of wheat. He violated it, he was penalized, and he challenged the constitutionality of that limit. And Filburn says, interstate commerce, what are you talking about? I'm not doing anything interstate, I'm just trying to feed my family, and I'm not engaged in any commerce. I'm not buying or selling this wheat, I'm growing it for my own personal use. And the Supreme Court, at the height of pro-federal power tendencies in the court that was reshaped by FDR by 1941, says to Filburn, too bad you lose. You may not have been engaged in interstate commerce, but if every farmer growing wheat locally did what you're doing, that will sort of affect things that are interstate, and that's close enough. And you may not be engaged in buying or selling goods, but you are producing and consuming a commodity, and that's close enough, and the regulation gets upheld. So you can see in that decision the incredibly expansionist tendency of the case law, pro-federal power, broad view of the Commerce Clause, pretty serious fudges on both interstate and on commerce. But think about how much farther this case is from even Wickard against Filburn, which is the high water mark of Congress's Commerce Clause authority. Roscoe Filburn was engaged in perhaps not commerce in the literal sense of the word, but he was engaged in what later cases describe as economic activity, producing and consuming a commodity, in that case wheat. Contrast that to people subject to the mandate who are not engaged in commerce or economic activity in any way, shape, or form. They are complete strangers to the health insurance market. They don't affect it in any way, shape, or form. Congress says to them, we're pulling you into the market. The analogy between our case and Wickard is not our case is like the facts of Wickard. The analogy would be if the New Deal Congress had told Filburn's neighbor, you must buy Filburn's wheat because we want to stimulate the demand for wheat. They never did that. It never even occurred to them that they could do that. And the final point I'll make is the consequences of upholding the mandate in this case. As I said, the Commerce Clause law turns on whether the activity in question has a substantial effect on interstate commerce. The issue in our case is sort of how that idea applies not to people who are in the market doing things, but to people who are strangers to the market. And can you say that the aggregate effect of everyone who doesn't buy health insurance has a substantial effect on the health insurance market? Well, if the answer to that question is yes, then so too will the answer to any question about any product you care to talk about, whether it be broccoli or General Motors cars or Citibank mortgages. The governing Commerce Clause rules don't allow distinctions, in our view, between healthcare and any other good or service. The government certainly tries to assert distinctions, but they're economic and policy distinctions. They're not distinctions that have any obvious hook in the law. So we think the consequence of the courts crossing this Rubicon and upholding this mandate would be to open the door to a wide range of purchase and sale mandates, which would allow Congress to transform the more or less free market economy that we have into a command and control economy where purchase and sale decisions are dictated not by individual consumers and sellers, but by congressional mandate. And if you think that that is an exaggeration by an advocate in the case, I will tell you that is not simply what I'm telling you today. That is what the Congressional Budget Office in 1994 concluded when analyzing the predecessor version of the mandate that was in the healthcare statute, not enacted then, but basically akin to what was enacted now.
Okay.
I disagree. First, I also want to thank you all for having us here on this beautiful night in this beautiful building. It's a real pleasure to be in Lawrence with all of you. I will say this before I start. I was talking to my older daughter, Lucy, about coming out here tonight and what Greg and I were going to be doing. And she sort of listened to me for a while, and she said, so let me get this straight. You are going to talk and talk and talk and talk and talk, and then they're going to ask you questions, and then you're going to talk some more. I said, that's about the size of it, yes. And she looked at me and she shook her head and she said, that's going to be so boring for them. So we will do what we can. I promised my daughter. A quick straw poll, just so I can get a sense of the audience. How many of you are lawyers or law students? So I assume the rest of you have managed to avoid being lawyers then. Good. So I want to start actually with a couple constitutional principles, a little bit more general than where Greg started with the Commerce Clause. One of the big issues in this case, and this is, I think Greg and I can fully agree, one of the most volatile, important, all-consuming, heavily written about issues that has come in front of the Supreme Court in a long, long, long time. But just because something is a hotly debated policy issue doesn't mean that it's unconstitutional. It doesn't even mean that it's of questionable constitutionality. And that's why I want to start with some of the basic constitutional principles. The Supreme Court has held repeatedly that when a law arrives at the Supreme Court for review, it is entitled to something called a presumption of constitutionality. And that means that the law cannot be struck unless there is a plain showing that the law is unconstitutional. That's the standard. And the court has elaborated on why that is. The Supreme Court and the Congress are coordinate branches of government. That presumption is a deference that is appropriately paid to the Congress, which after that long, arduous sausage-making process of putting this law together, is entitled to a little bit of deference that the law that it made is going to withstand constitutional review. So that's point one. Point two is something with respect to the Commerce Clause specifically. When Congress litigates under its Commerce Clause power, it is entitled to be upheld if it can show that it has a rational basis for its conclusion that what it is seeking to regulate impacts interstate commerce. And for those non-lawyers in the room, rational basis, if you ask any lawyer will tell you a rational basis test is basically, does it pass the laugh test? That's the rational basis test. So if Congress has articulated in this Affordable Care Act with respect to the individual mandate a rational basis for its belief that the individual mandate and what it seeks to regulate impacts interstate commerce, that is entitled again to deference from the reviewing courts. So now let's talk a little bit about what exactly it is that Congress was seeking to regulate. And this is really the semantic and the policy nub of this issue. Because what you've heard Greg talking about is an act that forces someone into a market that that person isn't in, right? Forces somebody into the insurance market to buy insurance who perhaps doesn't want to buy it. But there is another market that all of us are in or will be in, whether we want to be or not, and that's the healthcare market. So just show of hands. How many of you have been either to a hospital or the doctor in the last year? Okay. How many of you in your lives maybe went to the doctor or the hospital not really intending to go to the doctor or the hospital, but just because you found yourself really needing to go to the doctor or the hospital? How many in your lives? Okay. That's the market. That's the market that we're all in, whether we profess to be or not, whether we want to be or not. And it's that market that Congress is entitled to legislate in. Congress, unlike some of its prior statutes, which I'll talk about in a minute, Congress made incredibly detailed and specific findings about the impact on the nation's economy of the uninsured, millions and millions of uninsured people consuming health care. And I'll give you a relatively local example. The University of Kansas Hospital in 2008 devoted $100 million of uncompensated care to uninsured people. That's just the University of Kansas Hospital. All of the hospitals in the Kansas City area, last year, fiscal year 2010, $222 million of uncompensated care that was not reimbursed either through the federal or the state or from private insurance. That's the market that we're talking about. So when you talk about whether someone is being forced into a market or forced to buy a good, there is another side to the story, and it's Congress's characterization of this as being a part of the healthcare market. Remember, this is a massive, massive bill that we're talking about. And the provision that is so hotly debated that we're here to talk about is a very small part of that bill, a very important part of that bill, and we'll get to that. But the overall effect of this bill is to make healthcare more accessible to more people in the country, and that's the market we're talking about. So a couple points on precedent. And I have Wickard right here. So let's start with Wickard. Whoops, there goes my itinerary.
You had Wickard.
It's gone. Thank you. I agree with Greg to a point, which is that Wickard is a very important case. But again, just like the debate that Greg and I are now having over semantics, there's also a debate over how Wickard gets read. Because one of the issues with Wickard is not so much that this farmer was growing wheat and could not put it into commerce because of those New Deal allocations. Let me tell you exactly what the Wickard court said. The maintenance by government regulation of a price for wheat undoubtedly can be accomplished as effectively by sustaining or increasing the demand as by limiting the supply. The effect of the statute before us, and I'm going to ellipsize a little bit, is to restrict the amount which may be produced for market and the extent as well to which one may forestall resort to the market by producing to meet his own needs. And I'm reading those last several words with emphasis for obvious reasons. There is an exact parallel between what the folks who are suing to challenge the individual mandate here are doing, which is purportedly forestalling resort to the healthcare market by either self-insuring or setting aside money to meet their own needs, and what the farmer in Wickard purported to do. There is no daylight between those two cases, except we're talking about wheat and healthcare. Other than that, it's exactly the same principles in play. Let me make one other point on precedent. For the last 70-odd years, there have been precisely two cases that the Supreme Court has decided a federal statute violates the Commerce Clause. Lopez was the first back in 1994-95, and then there was a case called Morrison in 2000. Both of those statutes had something in common. They were both targeted criminal statutes that purported to federally criminalize acts that were quintessentially within a state's police power. So the Lopez case had to do with a federal criminalization of merely possessing a handgun within 1,000 feet of a school. The justification for why that was permissible under the Federal Commerce Clause was actually nowhere in the statute. Congress actually made no findings about the relationship between holding a gun near a school and commerce. But they tried to offer it during the Supreme Court case, and what came out was something like this. Well, if you have a gun near a school, there might be violence, and if there might be violence, it might be distracting, and maybe people wouldn't be educated as well, and if they're not educated as well, they wouldn't get good jobs, and the economy would suffer. I'm not making this up. This is actually what they were arguing. And the court said, no, there are limits to the ability to, as one justice put it there, pile inference upon inference to get to the conclusion that something that is purely local and purely non-economic, holding a gun near a school, is going to affect interstate commerce. Very similar result in the other case I mentioned, Morrison, also a federal criminal statute In that instance, it was purporting to federally criminalize gender-based violence, for example, domestic violence. Similar arguments were made, this time in the statute themselves, that domestic violence has an impact on national productivity because it constrains people's travel, it constrains people's ability to work, and so forth. And the court said no. Again, first, this is something that the states are very capable of regulating themselves, and many do. And second, the inference upon inference is simply too much. Here, this is a one-step conclusion. Uninsured people consume $43 billion a year in uncompensated, in medical care, uncompensated medical care. That's the economic impact. It affects all of us nationally. And that's the difference between this case and the only two cases in the last 70 years where the court has seen fit to strike down a considered act of Congress under the Commerce Clause.
Do you want brief rebuttals, or do you want me to go to questions?
Either way.
Well, why don't I throw this out? You've both talked about the commerce power, and obviously that's been a focal point in the cases, but it's not the only possible justification for this law. And so I wondered if you'd both comment on other arguments that are out there. For example, necessary and proper clause has been referenced. There's a lot of argument about taxing power, and kind of discuss how those other power arguments might come into play here.
Sure. There are really three asserted justifications, constitutional bases for the law: the commerce power, which we've been talking about, the necessary and proper clause power, which I didn't talk about because I think the analysis there largely, although not entirely, overlaps with the commerce clause power. And finally, the taxing power, which I didn't talk about because I think the federal government's taxing argument is substantially weaker than its commerce argument. On necessary and proper, there are debates about the extent to which the doctrines that Kate and I have already been talking about are Commerce Clause doctrines or necessary and proper clause doctrines. I don't think ultimately anything matters in terms of whether you call it a Commerce Clause argument or whether you call it a necessary and proper clause argument. I think the debate is joined in the same way. There is a separate pure necessary and proper clause argument in the case, which I didn't mention in my opening in the interest of brevity, which is the government's argument that the mandate is justified, even if unjustified as a pure regulation on commerce, it's justified as necessary and proper to other health insurance regulations that are themselves regulations, permissible regulations of commerce. Those are the guaranteed issue and community rating requirements, which basically convert health insurance from a more or less market good that people have to buy and pay for at whatever prices the market provides to more or less an entitlement. The effect of the statute is that guaranteed issue is everyone who goes to a company and says, give me health insurance, is entitled to get it. Community rating is that the insurance company basically has to charge everyone the same amount regardless of the individual's actuarial risk. That's a terrible deal for insurance companies because they're forced to underwrite really bad risks to high-risk people, and they will predictably lose a lot of money in that sort of arrangement. The experience of states that try those provisions is low-risk people opt out of the pool, costs go up, insurers stop writing policies. So the theory goes Congress's response to that problem, which are regulatory costs of basically creating this entitlement to health insurance, is the mandate, which basically forces the low-risk people into the insurance pool, and they have to buy insurance at average rates. It's a bad deal for the low-risk people. It's a good deal for the high-risk people. It all washes out. The insurance companies can go on providing their business, and everyone gets health insurance. That's the theory of it in a nutshell. They say you can't have the guaranteed issue and community rating provisions unless you have the mandate. That's the necessary and proper argument. And I think our response on those points largely parallels our arguments on the Commerce Clause points, in that this has never been done before. This kind of thing has never been done before. This sort of idea of an offsetting power, that the government can use the necessary and proper clause not to sort of implement a system of regulation, but to make one group of private people, the people who don't want insurance, sort of pay for the cost of the system of government regulation. Just to give you some examples of the implications of that, go back to Wickard, which does seem to me different for reasons I said. Government prohibits farmer Filburn from growing more than a set amount of wheat. That's bad for farmer Filburn. The government offsets that by forcing Filburn's neighbors to buy his wheat. And that leads you to the same result, which is this unconstrained power to make people buy things that they don't want. Go forward to the civil rights era cases. The hotels and restaurants who wanted to discriminate in the South on the basis of race in the 60s said, look, we may not want to do this ourselves out of our own hearts, but unless we do this, we'll lose lots of business, just because that's the nature of our clientele. Congress says, too bad, they lose lots of business, that's bad for them. Can Congress, through its necessary and proper clause, offset the losses to the hotel managers and the restaurateurs by forcing private individuals to frequent restaurants and hotels? One would think not. And finally, to fast forward to the present day and the mandate, Congress, as I said, through guaranteed issue and community rating, effectively, plus the mandate, effectively forces low-risk people to subsidize high-risk people. Can Congress offset those costs by imposing on high-risk people, and imposing on everyone, healthy lifestyle choices, requirements to buy broccoli and join gym memberships and so on? Would seem that if this kind of offsetting theory, that Congress can use the necessary and proper clause to make private parties who are strangers to the regulated transaction kind of pay into the system to offset the regulatory costs. If that theory were good, Congress could do all of those things, which leads to this brave new world of unconstrained federal power. And the one thing the Supreme Court has said in all of these cases, both the ones that I rely on and the ones that Kate relies on, is that whatever your theory of Commerce Clause or necessary and proper clause power is, if it leads to the conclusion that Congress's power is essentially unbounded, it has to be wrong. Because the one thing we know crystal clear from the Constitution is Congress enumerated the powers and reserved everything that was left to the states and to the people, and that whole exercise would be pointless if one of the powers were so broad as to let Congress do everything. So that's the necessary and proper argument in a nutshell. The tax argument, I think, is clearly the weakest of the government's three lines of defense. They try to defend the mandate as a tax. There's statutory problems with that insofar as the mandate is expressly described in the statute not as a tax but as a penalty. Many other provisions in the statute use the word tax, so presumably Congress knew how to distinguish taxes from penalties. If you're a justice who cares about legislative history, you would find that predecessor versions of the statute described the mandate as a tax. That term was specifically taken out, one would think, for a reason. And not only Congress, but the President of the United States, in trying to sell the statute, said until he was blue in the face that the mandate was not a tax. And it's a little surprising that my successors in the civil division would run an argument so clearly contrary to what the sitting president's views of the statute were. There's a settled distinction in the case law between taxes and penalties. The concept is a simple one. A tax is a payment for the support of government. There's a tax on, say, cigarettes. I pay the tax on cigarettes. I buy cigarettes, I pay the tax. I'm supporting the government. I'm not violating any law by smoking the cigarettes and paying the tax. That's different from a penalty. Here, there's a prohibition on being uninsured. If you violate that prohibition, you have to pay money to the government as a penalty. Forget about the money to the government as the penalty part of this. The key point is there's a legal prohibition on being uninsured. The person who pays the penalty isn't simply lawfully paying a tax. He's paying money to the government as a legal consequence of violating a separate federal statute. If that is not a penalty, nothing is. Another way of making the same point is that if the government's tax argument were right, then the government's tax power would be unlimited. Because think of any example of something you think the federal government shouldn't be able to do. Regulate family law, for instance. Under the government's taxing theory, Congress could pass a marriage statute that says, Section 1, it is illegal to get married. This is an absurd statute, of course, but I'm making the analytical point. Section 1, it's illegal to get married. Section 2, if you get married, you pay a $1,000 penalty. Does anyone seriously think that that hypothetical prohibition on marriage would be perfectly good because it's paired up with something, with a penalty that is recharacterized as a tax that somehow insulates not only the order to pay the government money, but the underlying prohibition? Of course not.
I think the marriage statute would be unconstitutional for a whole bunch of other reasons, but let me start with the tax and work my way back to necessary and proper, because I actually think I'm not going to join issue too much with Greg on the tax power argument. This is an argument that one federal appellate judge out of the many now that have looked at this issue has seized on, so far at least. And I think I do agree with Greg that it's a relatively difficult argument given the precision with which Congress referred to this particular payment as a penalty, and also in the same law referred to other issues relating specifically to taxes or tax exemptions, tax credits, and so forth. That said, I don't think it's I think it is still an argument that can and clearly has been made with a straight face. For this reason, the court has said on multiple occasions, Congress can call it whatever it wants, but if it's a tax, it's a tax. And as far as this being a revenue raising or not a revenue raising a type of payment, the projected revenues accruing to the federal fisc by virtue of the penalties, if we will call them that, paid by folks who don't get insurance are on the order of billions of dollars. So this is not, I think, a simple walk-off argument for the challengers, but I do think that it probably is, and the courts have found it is an argument of far lesser strength than the Commerce Clause argument. It's a little bit harder to navigate through all of the language about penalty and so forth. On necessary and proper, on this too, I think I agree with Greg to a point, which is the necessary and proper arguments and the Commerce Clause arguments merge, but my thinking about them obviously is a little bit different. The court on several occasions, most recently Justice Scalia in a case we haven't yet talked about, which is a case from a few terms ago called Gonzalez versus Raich. Justice Scalia made the point that when a provision of a statute is an essential part of a broader regulatory scheme, even if that provision impacts wholly intrastate conduct, that provision is still perfectly valid, not under the necessary and proper clause in that case, but under the Commerce Clause. So to a certain extent, when we're talking about whether the force of this particular statute comes through the Commerce Clause jurisprudence or comes through the necessary and proper clause, to some degree, I think we kind of end up in the same place. But on the necessary and proper clause itself, let me say this, we're actually sitting with a moderator who filed an amicus brief in the most recent, very high-profile necessary and proper case that came before the Supreme Court a few terms ago. And it's a fascinating case called Comstock. And it had to do with whether the federal government, and Steve is going to correct me if I go off the rails, so I'm speaking very carefully, whether the federal government essentially could keep confined a certain very narrow class of federal sex offenders past the term of their Bureau of Prisons sentence if they found that they continued to be dangerous to the community. And the answer under the necessary and proper clause was yes. So if Congress can keep people in prison under the necessary and proper clause as an accompaniment to its other powers, query why Congress couldn't have people finance their health care now rather than later under the Health Care Act.
Okay. And I won't comment on Comstock, but it was noted at the time when the court decided there were certainly people observing that it might play into this healthcare law constitutionality debate. Well, I want to shift gears. We've been pretty intensely constitutional, but I suspect the audience would also be interested in, you're both very experienced litigators involved in these cases and others. Talk to us a little bit about which, or if any of the cases the court might take, why it might take one over another, and then also timeline, and if you're willing, maybe a prediction as to where you think the case will come out.
The court has to take one of these cases at this point. The courts of appeals are divided on this question, and one court of appeals has struck down a substantial provision of a major federal statute. Either of those considerations very likely gets you Supreme Court review. Both of them together makes it a certainty. The federal government recently eschewed its opportunity to go back to the complete 11th Circuit in order to try to undo the case that we won that was unfavorable to the federal government, that could have made the lower court division go away and could have eliminated the only appellate case to strike down the mandate. To our surprise, they didn't do that. So they've pretty much committed themselves, and in the process committed the Supreme Court to taking up the issue. The real question is, which case or cases will the court take, and what ancillary issues will the court take up along with its consideration of the mandate? And those two issues are somewhat related because some of the cases raise some of the issues, and others don't. Some of them raise the issues in a better format than others. I think, not surprisingly, that my case is by far and away the best one. I have some selfish reasons for saying that, but I do think if you asked around, most lawyers following this case would probably back me up on this one. My case is the one out of the 11th Circuit. We have, I think, the best set of plaintiffs from the court's perspective. We have both private individuals and states. We have two private individuals whose legal standing is unquestioned, and we have a private organization that is not an entity created for the purpose of doing this litigation. It's not an ideological litigant. It's the National Federation of Independent Business, which is to small business as the Chamber of Commerce is to large business, a very substantial business group representing a broad range of private interests. We also have 26 states. This is the first time in American history that a majority of states have joined a single lawsuit to challenge the constitutionality of a federal statute, and that, I think, gives our case a gravity that it otherwise wouldn't have. We think we have the best plaintiffs. We also think we have the best issues. Our case is the only one in which both the mandate question was decided and then a follow-up question of severability. The severability question is, what happens if the mandate is struck down? How much of the rest of the statute survives? That is a surpassingly important question with respect to a statute that requires individuals to plan for having to buy health insurance. That's the piece of it we've been talking about. But above and beyond that, requires employers to wholly restructure the benefits that they have to provide employees, requires states to dramatically expand and restructure their Medicaid benefits, requires the federal government to stand up whole new bureaucracies to implement and administer the statute. If all of that were cast into doubt because the mandate were struck down, why in the world should the country wait 1 or 2 extra years to find out whether the rest of the statute will survive and whether this massive program of implementation is all for naught? So we think it's very important that severability be in the case along with the mandate. Our case squarely presents severability as well. It was preserved by the parties and decided by the 11th Circuit. There are 2 other cases in the queue that might be part of the mix. There's one case out of the 6th Circuit which rejected a constitutional challenge to the mandate in a private party case. We think that case is not as good as ours because those private parties have standing problems. Standing is a technical doctrine about whether the individual plaintiff can raise the claim. The court is going to take this case to decide the merits. They don't want to take the case and then have that be frustrated because there's something wrong with the individual plaintiff before them. That risk is higher in the 6th Circuit case than it is in our case, which I think cuts in favor of our case. And in the 6th Circuit case, the severability issue was neither addressed nor raised by the parties. One could argue that it should still be in the case, but the fact that it wasn't raised and addressed at least raises a question whether the court could easily get to it, which is not present in our case. So I think our case is clearly a better vehicle than the 6th Circuit case. There are 2 cases out of the 4th Circuit in which that court refused to consider the constitutionality of the mandate for technical jurisdictional reasons. One of the cases said that states are not the right party to challenge the mandate. The other case said that private parties cannot challenge the mandate unless and until they pay the penalty, which is a conclusion that sort of flowed from a view of the mandate as a tax. None of those cases reached any of the constitutional questions that we've been talking about. Those are the questions that are the most important ones in the case. Our case presents them. That makes our case better than the 4th Circuit cases. The 4th Circuit cases are a complicating factor because they arguably rest on jurisdictional grounds and the court has to consider issues of jurisdiction. If the court thinks that those grounds really are jurisdictional, they can address them in our case no less than in the 4th Circuit cases because jurisdictional issues have to come up in every case. So for all of those reasons, I think ours is the best one. Whether or not they take ours plus 1 or 2 of these others or just ours and hold the others, I don't know. My guess is they'll only want 1 case. It just makes their life a little bit easier. There's no issue in any of the other cases that they can't address in the context of our case. With respect to scheduling, the 6th Circuit case is the first one in the queue. That will be ripe for a decision, not on the merits of the case, but on whether the Supreme Court will hear it around the end of October. We are getting pressured by the Supreme Court Clerk's Office to expedite our briefing a little bit so that our case can catch up to that one. If we will do it. It's a question whether the federal government will or won't. If everyone in our case expedites, we will have a decision in our case by the end of October and likely an oral argument date in the Supreme Court in February. If there's no expedition, we'll likely get a decision a couple weeks later and have an oral argument date in March. Whenever the oral argument or arguments are in whichever case they take, however that plays out, ultimately that leads to a decision at the end of June. A case of this magnitude and complexity is almost certainly going to come down in the last day or week of the term, which is the last week in June. So I think all of the scheduling issues are sort of relatively minor details, and we'll get a decision one way or the other at the end of June.
I have equal skin in the game because I filed briefs on behalf of the American Hospital Association, Association of Medical Colleges, Catholic hospitals, public hospitals, in all of the appeals. So for me, any case that comes up is going to be a case that we're going to be involved in. There's an old musical, I think it's from Damn Yankees, with a song called Whatever Lola Wants, Lola Gets. There's a corollary in Supreme Court practice, which is whatever the government wants, the government gets. When the government seeks certiorari, there is about an 80 to 85% chance that the court will grant it. If a private citizen seeks certiorari, you're talking about a 3 to 4% chance. So that's why I say, whenever the government wants, the government gets. The government has sought certiorari, and it has sought certiorari in Greg's case. The 11th Circuit case out of Florida, that was the case that decided against the government on the constitutionality issue. It did decide, and this was the point Greg was talking about, that that one provision can be excised from the rest of the act without the entire act falling. That's the severability issue. So right now there are, in the 11th Circuit case alone, competing cert petitions, petitions for certiorari coming up from the government and from Greg's clients, and separate petition from the states, correct? All asking the court to review that case. Odds are very strong, I agree, that that will be the case that the court grants. The 6th Circuit case, there were some standing issues, and by standing we mean there were 3 individual plaintiffs in that case. One of them, the lead plaintiff, it was discovered about a week before argument, had purchased insurance, which called into question whether she could press an argument that she shouldn't be required to purchase insurance. Courts are rightly wary, particularly the Supreme Court is correctly wary of granting review in a case where the foundation for the grant might be taken out from under it, so I do think that's an appropriate concern. The 4th Circuit case and the jurisdictional issue of which Greg spoke, it has to do with something that we haven't touched on, I think, called the Anti-Injunction Act. And this gets back a little bit to the tax discussion we were having. There is a statute that prohibits any federal court from hearing any challenge to the assessment or collection of a tax. And what that means is that a court, no matter how much it might want to reach the merits or the substance of that challenge, if the court concludes at kind of that threshold review, that jurisdictional review that Greg mentioned, that this case is a challenge to the assessment or the exaction of a tax, it may not go any further. It has to stop, because it doesn't have jurisdiction to do anything more. That's what a majority of the 4th Circuit concluded, was that its review was barred by the Anti-Injunction Act. Now, the tricky thing is, because that is a threshold issue, the Supreme Court is going to have to address it probably before it gets to talk about any of the other issues we've been talking about. The strange thing in the 11th Circuit case, though, if memory serves, is that the government really hasn't pressed the Anti-Injunction Act issue. So what the government has done in its petition for certiorari to the court is it said, right at the end of its petition, it said, oh, and by the way, if you're interested in that whole Anti-Injunction Act thing, you can appoint somebody else to brief that particular issue if you want to collect that jurisdictional question within your review of this case. So I think Greg's quite right. The 11th Circuit case is probably the most collective and expeditious way to get all of these issues in front of the court. There are huge benefits, though, to all of these courts having already taken a look at these issues and come out in many different directions on them. Some time ago, right when these lawsuits were first being filed, there was an effort made by the Attorney General of Virginia to fast track his case right up to the Supreme Court. Basically, without pass and go, just go to the Supreme Court. Don't stop at the 4th Circuit Court of Appeals. And On the week that he filed his request for fast-track review, I was at an event in Washington where one of the justices was speaking. And the justice who was speaking said, in response to a question, that one of the benefits of having really important issues cycle up through a number of different circuit courts was that they could get a sense from all of these experienced, thoughtful judges, and these judges sit usually 3 to a panel on all these different courts. So you're talking about a decision so far from 9 judges, all of whom I think have filed separately to one degree or another, talking about these issues. That's a huge benefit to the 9 justices who are going to have to grapple with these issues for presumably the last time. That's what we're seeing with all of these decisions coming out. And if there's one decision that I would commend to you, Greg's going to commend to you the 11th Circuit decision. It's this thick, give or take. That's not the one I'm going to tell you to read. I'm actually going to tell you to read one from the 6th Circuit. And it's a concurring opinion by Judge Jeff Sutton. And Jeff Sutton is a name you might have heard before because he is the first Republican appointee judge to find that the mandate is constitutional. Relatively newly appointed judge, and the force and the lucidity of his opinion and the extent to which he had to grapple with a lot of these issues, I think is really, it's an extraordinary effort, and I commend it to you for a little bit of weekend reading.
Okay, well, so before we turn to the audience for questions, you did both avoid any prediction. Do you want to suggest a prediction and with any explanation behind that prediction?
I'm happy to give a prediction, but I have to give a caveat, which is because I represent a number of amici in this case. It's important that everyone understand that my prediction is mine alone and not my clients, not my firms, not anything like that. If you want more weekend reading, I would suggest to you to go back and read Gonzalez versus Raich, which was the opinion I mentioned a little while ago, and particularly read the Justice Scalia concurrence. And then go ahead and read Comstock, Steve's case. Because my view is that this is not necessarily going to be one of those neatly ideologically divided cases where you have 5 Republican appointees coming out one way and 4 Democratic appointees coming out the other way. My prediction is that it's going to be a 7-2 vote in favor of the constitutionality of the individual mandate. I think that a majority of justices will conclude that there really is no daylight between this case and the many, many other cases where they have found that the Congress, giving Congress the deference that it deserves, has properly exercised its vast commerce power. I think the justices will conclude that the differences between this case and Lopez and Morrison, which are the 2 cases I mentioned earlier, are so substantial that they cannot be categorized in the same way. I think the 2 dissenting justices will be Clarence Thomas and one other to be determined later. That's my prediction.
I don't feel comfortable as party for, as counsel for what I think will be a party in the case, definitively making a prediction. I will say that this is one way or the other, this is a case of first impression. This statute goes farther than any other has ever gone before, and therefore the court will be asked to break new ground. I think they will regard it as a close and difficult case. I think both sides have a pretty good fighting chance, and I think I'll just leave it at that.
Okay. Well, I think if we've got our microphones ready, we take some questions from the audience.
It seems painfully obvious to me that Clarence Thomas should recuse himself. What happens if there's a 4-4 vote in the Supreme Court?
If there's a 4-4 vote, the lower court decision, it's as if the court never took the case. The lower court decision stands. That is very problematic in a situation where the lower courts themselves are divided. I think the 11th Circuit judgment in our case would be binding on the government with respect to the 26 states who are party plaintiffs, and with respect to everyone who is a member of NFIB. I think that would be the best thing to happen to my clients' membership rolls. That's a pretty gaping hole in the statute. I think probably if the 11th Circuit decision stands, that's functionally more like the court striking the statute down than like the court upholding it.
But only functionally. I'd have to agree to an extent that it would get very, very messy if the court is divided 4-4 and if a justice recuses. But one point of clarification, just so everyone is on the same page, when that happens, it is not as if the court actually has taken up and decided and affirmed what has happened before. I think the exact nomenclature is the decision below is affirmed by an equally divided vote. So there is no sense in which that kind of 4-4 division would suggest a ruling on the merits of the case before it.
It doesn't resolve anything one way or the other, which
Right.
leaves the country in a bit of a pickle.
That's the legal term, it's pickle.
Greg said that the individual mandate requires somebody who doesn't want to buy health insurance to do so. And Kate said, well, don't define the market as health insurance, but rather health care, and everybody's in the health care market. And my question is, how crucial is that issue of defining the market? In other words, Greg, if you have to start with the premise that the market is health care, what's your argument? And Kate, if you have to start with the premise that the market is health insurance, what's your argument?
I think it's an awfully crucial distinction. It's a little hard for me to answer the question in the terms that you pose it, precisely because the statute so clearly operates on the insurance market rather than the underlying healthcare market. The statute requires people to buy insurance regardless of whether or not they receive care at all, much less receive care and then don't pay for it, which is the problem that Congress is ostensibly addressing. And it doesn't, in the healthcare market, the statute's sort of indifferent on whether someone has insurance or not. You get health care, the statute doesn't really address that. It's all about the health insurance market, and the government's theory is that even though we are regulating the health insurance market, we're doing so because of things that sort of may happen at some point in the future in the services market. I think my answer is really to just hold the line on what market the statute is actually operating on.
And I'm actually happy to play in the insurance market side of the ledger. The notion that this is just about buying insurance on the off chance that something might happen blinks away all of the congressional findings about what is happening in the insurance market. What we're talking about is a question of the timing of financing. You can either buy insurance against a future risk or you can self-insure against a future risk. The whole point of insurance is that you don't know what's going to happen or when. You don't know if you're sitting in your living room doing nothing, which is the common refrain of the challengers, whether you're going to have a pulmonary embolism in an hour. That's the reason why you manage the risk. Some people take that risk upon themselves, and some people get insurance. We are only talking about financing the risk. The other example that they love, and I won't even dignify the broccoli example, but the GM car. The difference between requiring someone to finance a potential, nay, actual future risk And the hypothesis of requiring someone to buy a GM car is this. You do not drive a GM car off the lot and tell the dealer just to bill your neighbor or to take the cost of the car on itself. That's what Congress has concluded happens every single day to the tune of billions of dollars in the healthcare economy. There is no sort of libertarian interest in free riding. We're just talking about, whether you want to talk about insurance market or healthcare market, we're talking about financing a risk and making different economic choices about when that risk is financed.
You spoke about the inequality of the young person getting a good deal and the old person getting a bad deal. But that seems to me an evaluation at a point in time, because the young person becomes the old person. And over the life of that person, he's going to have an average cost of health care. So shouldn't we be, do you look at this in a point of time or in the lifetime of a consumer?
I mean,
Let me pick that up first, actually, because I think it dovetails very nicely with what I was just saying. I think what challengers to the statute do when they talk about the living room inactivity example is essentially to take a snapshot of a person at a particular time who is uninsured, who does not need insurance, who is healthy as a horse, who's 38. But your point, I think, is quite valid, which is what we were talking about a few minutes ago. This is perhaps the only market, and this is one of the things that Judge Sutton talks about in the decision I assigned you for your weekend reading. This is the only market where you really do not know what is going to happen tonight, tomorrow, next week, next year with your health or the health of one of your dependent children. You can't plan in the way that you really even can plan for setting aside money for food, shelter, transportation. And I think your point about looking at someone over their whole life and saying, I may not need it now, but I'm sure as heck going to need it later, is a very valid one, and one that I think Congress took into account.
so the distinction between health insurance and other markets seems to me it's the point Kate just made doesn't distinguish health insurance from any other kind of insurance market. There are all sorts of insurance, all manner of insurance against, by definition, risks that are hard to predict in advance and unknowable. There's health insurance, there's flood insurance, there's long-term care insurance, Lord knows what else. I think if the argument works for health insurance, it works to any other kind of insurance. The phenomenon of cost spreading is not unique at all to healthcare. Cost spreading happens anytime any private individual engages in a contract to pay for goods and services and defaults on the contract. It happens every time there's a bankruptcy filing. The idea that people are obligated, there's a societal judgment that everyone should have health care. That really doesn't distinguish health care from food, clothing, shelter, transportation, lots of other life's necessities. So I don't think that the sort of factual and policy-based distinctions of the healthcare market from all other markets work very well on their own terms. But even more fundamentally than that, I don't think the distinctions are relevant to the constitutional questions before the court. The constitutional question is, can you say that commerce is substantially affected by the sum total of thousands, if not millions, of non-purchase decisions? If the answer is yes for healthcare, the same logic inexorably will produce a yes for any other product, including broccoli, by the way, that you care to name. So I don't think that the government's arguments, either factually or legally, sort of limit this purchase mandate power to this market and only this market. One last thought, which I think goes to both of the last two questions. There's the idea that even though what the statute actually does is force people into the health insurance market, it's okay to think of it as if it were regulating the underlying health services market because, well, most of the people in or not in the insurance market are consumers in the underlying services market, so there's not that great a difference between what Congress actually did and its asserted interest. Let me talk about one other case, which I haven't mentioned, but Kate has, which is the Lopez case. Lopez is the case that struck down, on Commerce Clause grounds, a prohibition against possessing a gun within 300 feet of a school, X number of feet of a school. I think it was 300. One of the arguments made in defense of that statute was, well, this is really crazy because it would be perfectly constitutional to prohibit possession of a gun within 300 feet of a school if the gun had moved in interstate commerce. So this distinction is wholly formalistic. 99.99% of guns have moved in interstate commerce, just like 99.99% of people forced into the health insurance market will at some point purchase the underlying services. And the Supreme Court said, no, that doesn't matter. That's not what this statute does. We're going to sort of judge the statute on its face for what it does. And in fact, after the court struck down the actual statute in Lopez, Congress responded with a different statute prohibiting possession of a gun near a school if the gun had moved in interstate commerce, and the lower courts have said that that's fine. So I don't think it counts against my argument that Congress could have passed a different statute addressing a different market that sort of in policy terms looks similar to the one that it enacted. The one that it enacted forces people into the health insurance market. That's what it does, and it raises all of the constitutional difficulties that I've laid out.
All right, I think if we do one more quick one, and then it's almost 10 o'clock DC time for our panelists.
We're fine.
But let's do one more, and then I'm sure they may stay around up front to chat with folks as well. So.
Ms. Stetson, you neglected to mention the name of the case that Judge Sutton wrote that concurring opinion on. Do you have it?
The name of the case is Thomas More Law Center, I believe, versus Obama. That does make it easier for you to do your homework.
And that's an easy question. We can do one more if you want.
I know the reason to remote the jump.
Hold on. Actually, there's several. The mic's back there. You had to think. Sorry. Go ahead.
Okay. I have a mandate question, and it's a historical one. If Congress, through the Trade and Intercourse Acts of the 1830s, could mandate tribes have to deal with specific licensed traders as they did, and tribes and states are both dependent sovereigns in the Marshall-Cherokee rulings of the 1830s, doesn't the federal power translate to the health care bill dealing with states as a dependent sovereign now?
Sorry, I'm not familiar with the example. Tell it to me again. What's the statute do? The 1830 statute?
You had the Trade and Intercourse Acts through the plenary power of the U.S. Congress in the
Right.
Commerce Clause. They had to license traders specifically to deal with Indian tribes. They had to mandate it. The tribes only had those people to deal with, and a lot of the times the traders stole the land.
The tribes could only deal with licensed
traders, yes. It was a mandate.
That seems to me pretty different.
Well,
I mean, it's just a standard licensing function.
They had plenary power over Indian affairs, and states and tribes are both dependent sovereigns in the Marshall rulings in Worcester v. Georgia and Cherokee v. Georgia.
So is your point is that, so the Commerce Clause we've been talking about actually has several different sub-provisions in it. One of them is that Congress has the power to regulate commerce with the Indian tribes. So I take it you're drawing an analogy between if Congress can say, tribes, thou shalt contract or conduct commerce only with these traders, states, thou shalt conduct what?
Before, in the Marshall rulings, when when the Cherokee rulings were going on in the 1830s, he ruled that tribes and states were dependent sovereigns. They
Yeah.
were dependent, they were sovereign to govern themselves, but they were dependent on the U.S. government for protection. What's the difference with the healthcare bill in states now?
I do think, I also confess unfamiliarity with that, but I think there is a little bit more of a licensing function, as Greg said, that is wrapped up in that. With all of the scholarship that I've read on the individual mandate, nobody has tripped to that yet, so I think you have a law review article in the making.
It's the difference. I won't speak to that statute. I'll try to make a conceptual point, which is it's the difference between Congress saying if you buy a good, if you choose to buy a particular good, you must buy it from a licensed provider. That seems to me core permissible Commerce Clause legislation under cases going back at least to the New Deal that we're not challenging. That does seem to me very different from what we have here, which is not, if you want to buy a good, you have to buy it from a licensed provider, but you must buy a good.
Okay. Barbara?
I am sorry. I don't know what happened to the mic here, but I'm sure you can hear me. You guys turn it on.
Take it from here. Thank you so very much. I hope you learned a lot about the constitutional portion of this and the mandate that they're looking at. As we brought the other case to you last year on the First Amendment, a lot of people wrote back to us that they didn't know the First Amendment was as complicated as it was. And I hope when you're looking at what the Supreme Court will be dealing with in terms of the mandate portion, that you will be enlightened. And when you read it, you go, I heard that. And when you see what the outcome is, I heard that. And I think it's a variety of things. But I think the most important thing about the Constitution is that everyone has their own interpretation, but you have 9 people that rely on appeals court and everything else in order to do it. And I think the 2 of you, with your moderator, has done an extraordinary job. And I want to give him a round of applause